Live stream on YouTube. Here we go. Welcome, everyone. Welcome. Hope you're doing well today. Great to have you on with us. Today's webinar, CUPA-HR Washington Update, How the DOL's Changes to Overtime Rules Will Impact Campus. My name is Brian Rowe, and I will be your moderator. Please note this event is being recorded, and all lines are muted. I'd like to take a moment and thank the organizations that partnered with us on today's event. AACRAO, AASCU, ACE, EDUCAUSE, NACUA, NACUBO, and NAICU. Thank you. Today's event is also being live streamed on YouTube to provide access to more participants. Welcome to our live streamers. The chat box will be used for questions and comments, including technical assistance in both Zoom and YouTube. Please also feel free to share your resources and questions with each other. We will do our best to address your questions today. And note for those in YouTube, we will pass those questions right along to our presenters, so feel free to include those in the chat as well. Closed captioning is available in Zoom and accessible in your toolbar from the live transcript button. The materials link has been posted to the chat box and includes PowerPoint slides as well as other curated resources concerning today's topic. Be sure to visit CUPA-HR's Knowledge Center later today. The Knowledge Center contains hundreds of resources and tools to support members in their everyday HR practice. The webinar recording will be available within a few days, and all registrants will receive a follow-up email. Thank you to Siegel for sponsoring today's event. And now, I would like to turn the floor over to Kelly Jones, Senior Vice President, National Higher Education Industry Leader at Siegel, to share a brief message and introduce our presenters. Kelly?
Thanks, Brian. Hi, and thanks for joining us today on CUPA-HR's webinar. This is an incredibly important topic for all of us, and we can tell by the number of registrations that it's really meaningful to you, so hopefully you'll get the most out of this. Siegel has been the firm of choice for institutions who are looking for a partner to create a dynamic and comprehensive human resources, benefits, and organizational development strategy to support your institutional goals. Our firm has been dedicated and is a cross-functional human resource solutions practice, and it brings to your institution a broad experience of deep understanding of the dynamics of today's evolving employee value proposition. Our size, decision-making process, and the way we work with you and our consulting philosophy enable us to really tailor what we do to suit each institution's needs. We offer trusted advice that improves lives. Now, it's my pleasure to introduce today's presenters. Many of you know Josh Ullman, who has assisted CUPA-HR in developing and implementing government relations strategy since 2005. And then joining Josh today is Laurie Bishop, who we are excited to have joining us today. Laurie R. Bishop is partner at Hirsch Roberts Weinstein, a firm whose practice includes advising colleges, universities, and nonprofit organizations on their policies and procedures and aiding them in various risk management decisions. Laurie is also a member of NACUA. Laurie and Josh, the floor is all yours.
Thanks so much, Kelly. And thank you, Laurie, for joining us today. We couldn't do this without you in your efforts here. We really appreciate them. And we certainly appreciate Siegel and, of course, you individually, Kelly, and your dedication to higher ed. So I want to start off by just letting everyone know this purpose of this webinar is to provide an informational overview of the DOL overtime final rule. The content shared during the webinar does not constitute legal advice, and we encourage members to speak to their institution's legal counsel about appropriate ways to implement changes on their respective campuses. To that end, I know some of you undoubtedly will ask some very pointed questions about whether this person or that person can be classified in a certain way. We won't be able to answer that for a variety of reasons. One is we're not giving legal advice. Two, one of the very difficult things about classifying someone under the FLSA is that it's not about their job title. It's really about what their specific duties are and doing a deep analysis on that. So getting the disclaimer past us, Madison, go ahead. We'll pop to the next slide here. So our agenda, fairly robust, and we're going to try to move through quickly so we have room for questions in the end. Basil Thompson from our team is collecting the questions, and we'll be helping Laurie and I sort through them. And we're lucky to have Madison from our team as well, who is moving the slides along and help prepare all the slides. So the agenda today, we have an overview of the FLSA and the regulations, the previous regulatory updates to the FLSA. We'll discuss that. And then we'll go into the 2023 proposal that came out, all CUPA-HR's advocacy efforts in response to that proposal, and then what DOL did with the final rule. And then we'll get to the meat of it, where Laurie's really going to dive in and help us kind of talk about what is the guidance, what's the impact of the final rule from her perspective as both a lawyer that regularly represents higher ed and also someone who acts as a general counsel for.
Hey, Josh, can you speak up a little louder?
Oh, sorry. Yep. And Laurie's going to help us at the end with the review of the overtime reg guidance and the impact of the final rule with her experience as outside counsel to many universities and then also inside general counsel to one. And then I will talk briefly in the end about the legal challenge to the final rule. With that, I'm going to hand it over to Laurie, who's going to talk about the FLSA itself and the overtime regulations.
Thanks, Josh. Hi, everyone. Thanks for joining us today. We want to start with a quick refresher on the FLSA. The FLSA is a federal law, of course. It sets the minimum wage floor and requires employers to track employee hours and to pay overtime premiums for hours worked over 40 in a work week. The FLSA contains some exemptions, the familiar executive, administrative, and professional exemptions. Those are the EAP or the white collar exemptions for employees performing certain duties. And for us in higher ed, there are some other specific exemptions with other requirements, like for teachers, sometimes coaches, and academic administrative employees. So it's important to note that the FLSA sets a federal floor. It says that localities and states can impose additional wage and hour requirements, and they do that. This includes things like setting more stringent requirements for overtime pay exemptions. This presentation is federal only, so check with your counsel on any location-specific requirements. Next slide, please. So to be exempt from these overtime requirements, employees have to meet a few tests. First, they have to primarily perform certain executive, administrative, or professional duties as defined by the Department of Labor and courts. This is not always the clearest analysis. It's not just a kind of check a box kind of thing, but we do a lot of looking at court cases and what the regulations say and try to find whether people can fit into those duties tests. Again, based really specifically on case-specific things. It's not just someone's job title. It has to be what they're actually doing. They must also be paid on a salary basis. Meaning basically their weekly pay doesn't change based on how much they work. And they currently must earn a minimum weekly salary of $684 or just over $35,000 per year. So a spoiler alert, the duties and salary basis parts aren't changing, but this salary threshold is. Next slide, please. So there have been a couple of notable regulatory updates or update attempts in recent history. If you're working in this area in 2016, you probably remember what the Obama administration tried to do. At that time, the salary threshold was just $455 a week or just over $23,000 a year. So they perhaps overcompensated and set it at $933 per week or over $47,000 per year and $134,000 for highly compensated employees. There were still no proposed changes to the familiar duties tests for the white-collar employees. This was proposed to take effect on December 1st. So we spent all of this time and worry getting ready for it. Then 10 days before it was going to become effective, a judge in Texas blocked it for all of us, and it was later rescinded entirely. Next slide, please. So perhaps realizing that it was time for an update from 2004 levels after all, the Trump administration raised the salary threshold to $684 per week, just over $35,000 a year, and $107,000 for highly compensated employees in 2019. And that's where we are today, at least for another month and a half or so. Josh?
Thank you so much, Laurie. Can everyone hear me? I changed my ear pods because there seemed to be difficulty there. Are we coming through all right? All right. I got, yes. Okay, great. So go ahead, Madison. Next slide. Let's talk a little bit about the proposed rulemaking that we had this year. So the Biden administration had said early on that they were going to tackle this again. They were dissatisfied with what the Trump administration had done, and then they were anxious to update, get an update in. So they got a proposal out, and the proposal was to increase the salary threshold to the 35th percentile of weekly earnings of full-time salaried workers in the lowest wage census region. This formula is similar to what the Obama administration had used, but was struck down by a court. Obama administration had used the 40th percentile, and the Biden administration said, well, that didn't work, so we'll drop it down to 35 and see if that sticks. Not probably the most sensible approach to go given the past litigation, but it is the one they took. We projected at the time that that 35th percentile, based on the DOL data, would be 6209 annually. So that's what we had thought at the time when the rule would go into effect. As Laurie indicated, there are no changes proposed to the duties or salary basis test. Go ahead, Madison. So let's jump to our advocacy efforts. We have been through this in 2016 and then again in 2019. So we did the same thing we do all the time. We got all the data we could from our salary surveys and all that information and tried to assess how this would impact campus. And then we put together comments on the proposal, and those comments outlined the problems we had and made some recommendations. Key among our recommendations were to extend the implementation time, because DOL had proposed 60 days to implement, which we're living with to some extent, but they had proposed 60 days to implement the 60,000. And then we had recommended that they use a lower salary threshold, one that used the formula that had been used by the Trump administration in 2019, which is essentially the same formula that had been used by the Bush administration in 2004 when they did their update. Go ahead. Thanks, Madison. So the final rule was a little interesting. We were expecting that the Biden administration would pretty much move forward with something that looked a lot like the proposal, but that's not what we got. It's a little bit different. So rather than one increase to the minimum salary threshold, we've got two staged increases. And then we do have, as they had proposed, the automatic updates, which they also proposed, the Obama administration proposed in 2016, which is automatic update every 3 years tied to the percentile that I chose. The Obama administration had tied it to the 40, and the Biden administration is tying it to the 35th percentile. And then we have no changes to the duties or salary basis test. Go ahead, Madison. So the current minimum salary threshold that we have right now that was put in place in 2019 is 35,568 per year. The statute, the FLSA, breaks it out per week, which is why we have it listed there. It's per week analysis, but I know to translate to salaries, it's much easier for us to look at that as an annual salary. Beginning on July 1st, 2024, it will increase to 43,888 per year. So where did they come up with that number? That is based on using the Trump administration and the Bush administration formula, the one that we have said they should be using all along. And many in the employer community have said, look, this keeps up with inflation if you do it every once in a while, and it really serves the purpose of screening out people who are obviously not entitled to the exemption. But the Biden administration looked at that as just an initial step, and then they want to increase the salary threshold on January 1st to 58,656, which goes back to their formula. And that would be a 60% increase. Go ahead, Madison, we're good. And I'll talk a little bit about why I think they did it that way and what it means for us all. There are a lot of political reasons for that. I'll talk about that on the last slide when we talk about legal challenges, why they did it, because a lot of that ties into legal challenges. Some of it's political and why not. So they also modified the highly compensated employees level. So currently, and we don't have it in this slide, but currently the highly compensated employee salary, the HCE salary, which has a lighter duties test, is at 107,432. The increase in the rule would bump it up to 132,964 starting July 1st, along with the increase to the minimum salary threshold. And then it would jump to 151,164 starting on January 1st. Go ahead, Madison. As mentioned before, we also have the automatic updates that they put in. They're occurring every 3 years, as the Obama administration had put in their final rule. The first automatic update would take effect on July 1st, 2027. And automatic updates would be issued in the Federal Register at least 150 days before they go into effect. And DOL reserves the right, based on responses it gets from that Federal Register notice, to delay the automatic update through a separate notice of proposed rulemaking process. So that would be really something that would occur, in the so they'd have the automatic update, they'd let you know it was coming, take comments, and then once they take comments, they may make another rulemaking to adjust whether they do the automatic update or not. Next slide. I'm going to hand it over to Laurie, who's going to talk about the impact of the final rule.
Thanks, Josh. Obviously, impacted positions are going to vary by institution, and the impact itself is going to vary a lot of times by geographic location. Sometimes just the ordinary standard wages that folks are paid and have to be paid are going to just naturally be way higher, and it's not going to matter. And sometimes they're going to be more on the line, and it's going to matter a lot more for different institutions and different roles. So the ones that are mattering for really are the folks who are currently exempt and making between the currently required $35,568 per year and the July 1st required $43,888 per year. So based on some CUPA-HR data, they expect about 11,000 employees to be impacted by the July 1st change. So these are some of the positions that may be impacted listed here. Again, this is really institution specific, and it's very hard to just pick out, titles of positions who may be impacted because the determination of whether people are exempt is so fact specific. But this is kind of a shot at things that that may be impacted, at least by this first change. One thing to note with positions like the ones that you see here, particularly the one with an asterisk, and you'll see on the next slide other ones too. You may want to consider also the exemption for academic administrative employees. It's sort of, at least in my experience, kind of little used, but it's for employees whose primary duty is performing administrative functions directly related to academic institutions or training in an educational establishment. So that's a mouthful, but to meet the exemption, the employee has to satisfy the salary basis test, and it can be the salary level test. But if they don't meet that salary level test, they could also meet the salary of at least the entrance salary for teachers in the same educational establishment. If anybody knows that number off the top of their head, and assuming that's lower than the required salary level of the new regulations, you could rely on this to maintain exemption for those employees. Again, their primary duty has to be to perform administrative functions directly related to academic instruction or training in an educational establishment. Those who do work that doesn't relate to the educational field, such as work in general business operations, it's not going to count. There are some kind of samples the DOL puts out there. So I note it just as a consider this as you're going through this. If you think someone might actually need that, it's sort of difficult to to parse it all out, to determine what the starting salary is for for teachers, but it's something you'll want to talk about with your own counsel if you think that kind of may save the day for some class of employees. Next slide, please. So if the January levels remain, the impact is bigger, obviously. According to CUPA-HR data, there's over 58,000 employees will be impacted. Obviously, that makes the reach broader and the cost higher. These are exempt employees making less than $1,128 a week, or less than $58,506 a year. That's when it starts to get a lot more real for many institutions, and we expect a broader hit there. But as Josh had mentioned, there's still some unrest of what may happen beyond July 1st. Next slide, please.
Hey, Laurie, just real quick on those data numbers, everyone should keep in mind, those are on the institutions that have answered our surveys. So obviously you can extrapolate that will be, while we get great survey response, we don't have every university reply to our surveys. So it's going to be a lot broader than those numbers, just based on the fact that we don't get replies from every university, college and university in the country. Sorry, Laurie, I'll let you go.
No worries. So how will institutions respond? That's the $1 million question, right? So there's three main options. Increase the pay, reclassify them, not exempt anymore, or restructure, change the positions entirely. But how do we get there? So the first step is to perform an audit. If you didn't already, you may have done that when we last spoke to you, or when you first heard about this. If you didn't already, you need to determine all of the exempt roles. You can leave out faculty and student workers. They're not bothered by this. We're going to leave out most coaches because they're probably going to count as teachers too under that exemption. And how many of those roles are actually filled right now? What are they? List out the roles. What do they do? And how much are they paid? So maybe you already did this before. If you didn't, never fear. You'd probably be doing it again, given changes in pay and workforce and things like that. So now's the time. Once you have a sort of view of all of the affected workers, and those are the ones who you classify as exempt, but are still making below what the July 1st numbers require, you need to make some decisions. So institutions are going to address this in many different ways. A lot of times it will have to do with how many, is a critical mass of employees? Is there 3-4 of them? And maybe we know we're kind of below and we are going to raise rates anyway. But some of the ways that this can be addressed, you can do a wholesale reclassification. Anybody who doesn't meet it, you're not exempt anymore. Or make pay raises. to anybody who needs it. So this one size fits all approach obviously simplifies things administratively, but there's issues with it too. So reclassifying anyone who doesn't meet the salary level, you'll need to keep in mind what that means for how much overtime you might end up paying and what that means to the employee. They often see it as a demotion. There's considerations also if you end up with exempt and non-exempt employees in the same role, just based on salary alone. That's okay, that's permissible, but it can be difficult to manage. Or just raise pay, easy enough, right? But of course, budgets don't always allow for that. And we also have future increases to think about. And this could also create a wage compression issue. If you're just going to just plain raise the pay, what about the employees already in more senior roles? Do they get raises as well? So another option, which I think is probably the most common one, is an individualized or role-based approach. That's going to take more time and thought. You're probably going to want to work with your legal counsel. Certainly HR is going to have to lead this charge. If the role is such that it can't be done in 40 hours a week, you'll need to consider the implications of raising the pay to maintain the exemption. If the role routinely clocks in at 25 to 30 hours per week, maybe reclassification is a better option. Let them be hourly, they're never going to get overtime pay anyway. Or maybe the role needs to be restructured entirely. If you have the resources and time, you should also use this time to carefully assess whether these exempt employees are properly classified as exempt in the first place, notwithstanding their salary level. So that is much harder, takes more time, takes more thought. You need to perform the duties test. If some people come out as questionable, like, oh, maybe in fact that doesn't exactly, meet the whatever executive exemption, whatever you had thought in the past, now's a great time to address a prior potential misclassification. Ordinarily, several months ago, maybe, this probably would have been my recommendation to do first, because it's a great time to do it. Realizing you have about 6 weeks to go, I understand that this may not be the first thing you can do. It can take a lot of time. But if you're able, or if you come across and you notice someone who's just notwithstanding salary amount, perhaps misqualified, it's a good time to make the switch. And general counsel can help with this. Once you've made those decisions, however you come to them, you've got to notify affected employees of the changes. And depending on how it's affecting the institution, you may be issuing some kind of statement to the institution overall. I don't know many institutions who are quite, at that level, but it's always something to think of. So if you're changing status, you need to consider how it's going to be taken by employees. As I mentioned before, many people view it as a demotion. They're not getting paid a salary anymore. Your comms department may be helpful if more than a few employees are affected, and certainly your counsel as well, to determine the best way to say this to people if they're going to change, one way or another. But as you've heard, there are some legal challenges expected and already afoot. So I'm going to pass it to Josh to talk about those.
Thank you so much, Laurie. Really appreciate it. So not surprisingly, and as we had in 2016, we are facing some legal challenges to the rule. We expect it'll be filed in the next few weeks, maybe next week. It will really focus on challenging the January 1st increase and the automatic updates. But there's some nuances here. The Fifth Circuit, which is one of the circuits out there, is considering considering a case where there's been a challenge to there being any salary level. And if the Fifth Circuit decides that, obviously we'll have a new regime possibly as that case gets more litigated. But one thing that could happen in the meantime is if we see a legal challenge, we could see the district court, which might answer the Fifth Circuit or be aware of the Fifth Circuit case and be concerned about what's going on there. District Court may ask DOL to extend that July 1st deadline. I don't know if that's going to happen. My guess is that's less likely than not to occur. So when you're thinking about legal challenges and what you do, for many of you who have scars from the 2016 endeavor, I would bank on moving forward with the July 1 change. I mean, there will be efforts. CUPA-HR is going to ask DOL to extend that timeline till September 1st, rather. And then again, the litigation could possibly end up extending the timeline, but there's no guarantees with respect to that. I think it's more likely, based on the past litigation, that the January 1 and automatic updates could get knocked out. Again, nothing definite here, but there's certainly a much stronger chance. I would say it's more likely than not to succeed, based on what we've seen in the past with what happened in Texas District Court on the last time this was challenged. DOL's rule is not significantly different than the 2016. They just moved it from the 40th percentile to 35th percentile. There's not a lot of rationale in there about why they need to do it. And again, the automatic updates present the same problems that it did in 2016. I think DOL implemented this the way they did because they knew that the January number was going to be vulnerable to legal challenge, and they knew the automatic updates were going to be vulnerable to legal challenge, and they wanted to get something enacted reasonably in time frame. So if they had to take the 43, which is based on, as I said, on the 2019 to 2004 formula, they'd rather at least take that part and get that increase and not have the whole thing quite as vulnerable to legal challenge. The other aspect of it, not to be overly cynical, but politically, that means you have an increase the president can tout as he goes into the election. We implemented this increase to wages. We did so, and he'll have a lot of time between July 1st and the election date to claim victory with respect to this particular issue and say, hey, everyone, we've been dealing with inflation. Inflation is really high, and I made sure, through my department, we're at least taking steps to address and bump wages in response to inflationary pressures. Very important statement he can make going into the election, which is important, obviously for the Biden administration. So I see two aspects to this. One is legally, this makes it a little more difficult to challenge and really provides the department with an opportunity to push through an increase that is not all that legally susceptible to challenge, and then also pursue the things they'd like to do, even though that those may not withstand a legal challenge. And then again, there's this political victory as well. With respect to that, I am ready to move on to questions. I'm going to just, I know there's been quite a few in the chat. I'm going to flag a few that came through. And I do encourage everyone to look at our resource page. We have links to DOL's guidance on these areas, and a lot of the questions I'm seeing coming through are answered primarily in the DOL guidance. With respect to a couple things, part-time employees, there is no, you cannot prorate the minimum salary threshold to address a part-time employee. That's not how it works. There is a question here with respect to whether you have an employee that works a certain amount of weeks. Laurie can speak to this a little bit more, but I'll get into it a bit. If their annual salary does not qualify them for the exemption, it's really tied to their weekly salary. But you have to remember, on those months they may be off or weeks they may be off, they cannot work at all. They cannot be available to work or anything else if you're going to try to do that. Laurie, go ahead and pipe in here, but that's my remembrance of that portion.
Yeah. That's basically it. You're calculating it based on the length of the contract, the length of the time they're actually working. So I think it looks like that's what people are kind of asking. Can we do it that way?
And you can do so, but you have to absolutely make sure, like, no email correspondence, no nothing. Correct, Laurie? Am I right that when they have
Right.
their time off?
Yeah.
Right.
Usually we don't have a problem when people have that time off.
Yeah, I'm sure they're not reachable at all. But the point is, you as the employer, you can't be trying to reach them. That can get you in trouble if they do answer. We've gotten a lot of questions about coaches. It really depends the extent to which the coaches are involved in instructing athletes. In that particular instance, they would be called a teacher and therefore not have to meet the salary minimum. But there are some folks that are described as coaches, those who recruit, those who really don't get into instructing the students that wouldn't qualify for that teaching exemption. I'm trying to look through here. And Laurie, obviously, if I say anything and I'm not complete.
There's a question, I think saw a couple questions about room and board.
Yeah.
And I know Josh has been making some particular efforts on that. So do you want to tell us about those to start, Josh?
Yeah, I mean, we have asked every time. So every time we go through this process, we ask DOL two things. We ask them to prorate the salaries for part-time employees, just because there are so many in higher ed that are, since we have flexible workplaces and all these things, we often offer half-time or things like that. And we do ask for the proration. And every time we're told no. The other thing we always ask for is, hey, what about room and board? We provide room and board. Can't we count this towards the minimum salary threshold? And the answer is always no. So we've been through that process 3 times and asked that 3 times, and the answer has been no.
Right. And that's because the minimum salary as defined here is specifically exclusive of board, lodging, or other facilities. So to meet this specific test, it says right there in the regs, you can't count that. They also, DOL, I don't know, helpfully or unhelpfully, mentioned that DOL did not, capital NOT, make any decisions on whether room and board will count towards total compensation in the final rule. So they didn't change how it was, which already made it clear it doesn't count.
And I think based on past conversations we've had with the department, it's about calculating the value. It is the big obstacle, and they don't want to get involved in necessarily that kind of math when you're getting into room board.
Which makes sense. It is hard math. There is a different section, I think section 3M, where you can use room and board, but only to meet minimum wage requirements. So that's for people who are already non-exempt. They're already hourly employees. And if you want to use some of that, get credit for some of that to reach the minimum wage requirements for those folks, that is a possibility. But even that, it's sort of fussy, and it requires you to look at, the actual true value of the dorm room you're giving to somebody. And that's not usually what you charge a student for it. So it's kind of a fiddly thing. And if that involves changing those people from exempt to non-exempt, you also have a lot more considerations about overtime and whether you have to change the role overall entirely. In other words, is it worth it?
A few questions have come across here. With respect to part-time coaches that are doing some instruction, if they qualify for the exemption, they qualify for the exemption, and salary threshold doesn't matter, because it doesn't matter if they're part-time or not, if they're engaged in coaching that would be deemed instructing a student. So part-time coaches, when we're talking about part-time employees, that doesn't really factor in. With respect to, I got a couple of questions here. Well, we don't track the hours of part-time employees, or it's variable. That's the whole kick here, right? So if you're going to have to reclassify some of those part-time employees because they no longer meet the threshold, you would have to count their hours and pay them accordingly. There are different methods for how you do that. Laurie can get more into this. You could pay them a flat amount since they're generally not exceeding 40 hours. You could pay them a flat amount for every week up to the 40. And then there's some other stuff you could do. Laurie, you want to talk a little bit about that?
Yeah, sure. There's this concept of salaried non-exempt, where it's ordinarily, and we always pay them hourly, but there is a separate way you can pay them via salary. I've always found that a little bit of a fussy process too, and kind of an easy to mess up sort of process. But people do it on occasion, but you really got to do the math too as to is it really saving you any money to do that versus just having them put their hours in. In other words, how much of an issue is it to really just track their hours? And is it worth the cost difference? Because you're going to have to kind of gross up on what you're saying the salary is, and you have to track anyway to make sure they're hitting minimum wage. You can set their salary level. It's something you think that's probably good enough, right? But you won't know if they're kind of working extra for whatever reason.
Right. So you're going to have to track their hours regardless, and keep a record because that's your requirement while they're hourly. Even though you may pay them just a flat amount, you still have to track those hours. And the fluctuating work week proposal, I saw a couple of folks ask about that. That's when you get into the situation where some folks may actually be working over 40 hours, and there's methods on how you can set their comp. But as I remember, I think Laurie said this last time through with respect to this, it's hard to do and easy to mess up. But I'll let her talk a little bit about that. We don't want to go too in depth, but it is a method that if you have employees you've reclassified, you could look into.
Yeah, I don't see people using it that much, and probably just for that reason. Kind of fussy to set it up and easy to mess it up and to track it. But all that said, and if folks really are facing, changes that are very meaningful to them and they're needing to handle these in some way, then that's another option. Just because it's something that, is hard to do and isn't ordinarily used too much, doesn't mean that now's not the time to look into it if you have to.
We've got a couple other questions about comp time for public colleges and universities. Can you talk a little bit about that, Laurie, and how that works?
Sorry, can you say that? You cut out for a second for me.
Comp time. We've got quite a few questions about comp time in public sector and the use of it. Can you talk a little bit about how that kind of works?
Sure.
And if you've even seen it in the university setting. I don't think I've ever seen it in the university setting, but maybe.
I don't work much in the public sector, so I don't have particular experience in it, other than knowing that's an option to use as sort of a compensation tool instead of overtime. But I've never done it, so I can't say as to exactly how that would work out in the public sector. I ask your general counsel.
Yeah, I mean, the one thing I can tell you all is it's a win-win for employees in some ways. We've looked at it, to see if we could do it in the private sector in Congress, and there's been fights about it. And I dealt with it years ago in K through 12, and then some police and firefighter work I did at the beginning of my career. But from my end, it just is, employees still get their overtime pay. They just have to delay that payment, and then they also get in and leave because they're actually getting paid leave later. So it may smooth out your budget over time, and that may be advantageous for you. But remember, from the overall perspective, you're actually having those employees take leave later, and they're getting the leave and that overtime pay they were entitled to. And the way comp time works is, you work over 40 and you bank time off at the 1.5 hours per 1 hour worked, in that overtime rate.
I'm seeing a lot of questions along the lines of, what do you mean by the starting salary for teachers with regard to the administrative exemption? The short answer to that is I don't know, and the regs don't really say. And I haven't dug into them extremely deeply for that specific point, but Josh and I have discussed it before as well, that that's part of the things that we note it, but I don't exactly know how to determine that and at what point in time. And something maybe easier for like a school district, K through 12 or something to make that determination, probably set more routinized there. But for an institution of higher education, I wouldn't know how I would go about determining that. And I don't know if I would be able with a straight face to say like, oh, this adjunct person are here. They just started the other day and this is what they're making. So it's difficult to determine that. And I don't have a good answer for exactly how to do it.
Yeah, Laurie and I have gone back and forth with this. I have a very conservative position on it, which is, that salary level has to be someone you have. I would have to be someone you have full time on salary. And you can't take someone you're paying piecemeal and then try to cobble that together. But that is, again, that's my guess. That is not, anything concrete. We don't have a lot of basis on how to define that particular salary exemption, because there's just not a lot out there beyond the DOL guidance. There's not a lot of litigation with respect to it or anything else where we get more clarity. This school, not that we want anyone sued, but there hasn't been court cases where we're like, oh, this school was sued for using that exemption and this is how it panned out and here's how courts have said and this is what DOL said in briefs. I don't think we have a lot of that.
I don't think so either, but you may be seeing, there's been a couple things that we've answered like not sure, and they don't really say. So DOL may be called on to be providing more guidance on things like this that in the past were, not used all that much, or you can kind of take an educated guess and it would be fine. But if you really want to use it more, I suspect DOL will be fielding itself a lot more questions on how does that work out again. And they'll hopefully, when they get around to it, provide us some guidance on that.
Okay, I'm thinking, hey, Basil, do we have any other questions in here you've seen a lot of that we're missing?
One question we've gotten quite a bit is what can you use to calculate the minimum salary thresholds or bonuses part of that? Are the value of any types of other benefits part of that? We've got a few questions on that. Laurie, I don't know if you can clarify that by any means.
Yeah, tuition. I saw tuition reimbursement was one of the benefits they were hoping would be included. Go ahead, Laurie.
Yeah, generally speaking, as I noted before, with room and board, those types of things aren't going to count. Tuition benefits and other extra sort of fringe benefits that are provided are not going to count towards this minimum salary threshold.
Okay. Go ahead, Laurie. Sorry.
I've seen a few people asking, what are the penalties for not raising the wages? What if we just ignore it? None. There are no penalties for not raising it, except for those people will no longer be exempt. And then you won't be tracking their pay, and they're gonna come to you soon and be like, I've been working 50 hours a week and I'm clearly not exempt, and you haven't been paying me this overtime. Thus I'm suing you, and you'll lose.
Right. And then you may get some penalties or other things included in the litigation.
Right. Yeah. And Wage Act litigation here in Massachusetts, extremely serious, very much so in California, some other states too. A lot of places that carries a lot of penalties, and it's definitely something to be careful about.
There's a little bit of reputational risk with it as well. Universities are sensitive to that certainly, and when we get into pay, that's not something the presidents want. Oh, you didn't meet your obligations under wage hour laws. That's a pretty severe stain, particularly if it was done intentionally. One other question I've seen a bit here is, with respect to the highly compensated employees, where have you seen that on campus, Laurie? We've got a couple of questions about kind of who that might apply to.
Yeah, and we were talking about this yesterday because I think that may be kind of a blind spot too. When I was telling you before, blithely, just go ahead, determine everyone who's exempt, and is, under this salary level, and that's kind of where you're going from. You take out teachers, probably take out coaches, but otherwise, there you go. Those are the people affected. But for highly compensated employees, it's different. They don't have to meet all of the same duties. They have to meet some of them, and they have to make this higher wage. I don't see it. I might not necessarily, but I don't see many HR departments being like, check the box for highly compensated. That's how we're going to get over this one. So not only do I not see that happening in the first instance, which I may just not be privy to, but I can't imagine at this time that the HR departments are pulling out their list of exempt employees that there's like next to it, it says which exemption, right? I mean, maybe people are keeping much better records than I'm sort of familiar with, but there could be situations where you may have determined that this one, because they're highly compensated, that's why they're exempt. So, they may be able to raise them, or you may determine that they're falling because of that. But it's one thing to know as you're kind of looking into these. If you determined that back then, if that's the exemption you're relying on, the bar is higher. But I recognize it's probably going to be difficult to go back and extrapolate. But I can't say I personally see it noted much at institutions as this is the thing to use.
Right. I mean, if you're paying at that level, it certainly gives you some more security if you face litigation down the road.
Yeah. I think
what
Arch, if you're paying that level, you can probably shoehorn them into a different exemption.
Right. One other thing I'm seeing a bit of, we talked a little bit about, if employees don't work the full year and that you're paying them, and then they stop working. I know there's a rule where you can spread that salary over the year. Just so let's say they would make enough on a weekly level to qualify, but you are allowed to spread that, and let's say you don't pay them the weeks they're not there. Well, that can get a bit complicated for benefit purposes and other things, but you're allowed to spread that salary over the year, long as you make sure that they have that time off, correct?
Right. And I think most of the people that are being paid on, 9 instead of 12 are probably teachers. Probably already subject to the special teacher exemption. It doesn't matter. There are some particular IRS rules, which I will not get into, about the 9-12 month split. But I don't think that it will matter most of the time here, because most of those people are they have that split because they're teaching.
Right. Okay. Basil, what else we got here? Okay.
Yeah, I think, that we've answered, a lot of them within the buckets that have come through. One thing that I'll note is, CUPA-HR did have a white paper put together in 2019 in response to the final rule that was issued back then. A lot of the guidance in there is applicable to this final rule as well. You're just going to have to change the numbers with respect to the minimum salary threshold. I'm going to include a link in there because it does talk about, partial year employment. We've seen a lot of that. Talks a lot about applicability to coaches, the applicability of the academic administrator exemption. I'm going to provide a link for everyone that has tuned in that will take you right to that now. And, just remember that the numbers in there are based on the 2019 final rule, but there is a lot of applicability to the final rule that will take effect on July 1st.
And
the rules. Oh, go ahead, Laurie. Sorry.
To that point, as frustrating as 2016 was, we all freaked out then. We thought about this a lot, and a lot of that guidance, the things that we thought of then, they still apply now. It's just change the number, change the year. So it's not like this is a whole new world. These are things that have been thought of before, whether it's from CUPA-HR or someone else. A lot of those earlier thinkings on these increases are particularly useful. 2016, because that would have been a huge jump too. So there was a lot of hand wringing and client alert writing over that, which may be useful to you now.
Yeah, actually, on that note, Brian, can we post Laurie's client alert there in the box? That'll be helpful. So, when we're down to this, we're got the last 5 minutes. I think we've gotten most of the questions answered here that have come through. Obviously, if there are more that come through, you can email me at julman@CUPA-HR.org. We can see what we can do or direct you into the right resource that we have. And then we'll be tracking this. Obviously, we'll be tracking, do we get fortunate enough to have lightning strike and the July 1st date gets extended? As I said, do not think that is likely, but we will be advocating for it. And then the litigation may allow some opportunity for it. And then we'll be closely watching the litigation and reporting to you, as it moves forward over the summer, what it looks like for the January date, and whether that is going to go into effect. I'm getting a couple of questions. I'll just answer that real quick. With respect to postdocs and everything, the salary threshold does apply to postdocs unless they're teaching. Then it doesn't. So it really depends on what the nature of their jobs are. All right. With that, Brian, I'll turn it back over to you.
All right, great. Well, thank you so much to our presenters, Laurie and Josh. Please do join me in thanking them, and I will say thank you for all the thumbs up and rounds of applause reactions that I see floating on the screen. Very nice. All right, so we appreciate Laurie and Josh for being here with us today, taking the time to review the new rules and provide us with a very, very good overview of the update to the salary threshold and overtime pay requirements and how they will impact us in higher ed. Thank you to our audience for your participation. The questions you sent in beforehand and during the event were very beneficial for us to have incorporate into the content, as well as address in the Q&A segment that we just concluded. Thanks again to Siegel for sponsoring our Washington Update series. And thanks again to our partner associations, AACRAO, AASCU, ACE, EDUCAUSE, NACUA, NACUBO, and NAICU. A couple reminders for everyone on. This webinar will be archived and available in the next few days. We will repost the link to the curated materials document in the chat for you, as well as the event evaluation. But please do take a moment to complete that evaluation for us. Should only take a moment, and it helps really give us some beneficial feedback to consider on future events. All right. Well, thanks again, everyone, for joining us. Hope you have a wonderful day, and we'll be in touch, and we'll see you next time.
All right. Thank you very much, Laurie.